Hello and welcome back. This is a section that is not covered in your course, and I thought it would be interesting for you to consider, given your course of study so far and what many of you do in your regular jobs and professions. And I've entitled this section, Individual Employee Liability in Illinois, Select State and Federal Statutory Claims and Related Case Law. In part, this is a presentation that I've made to a bar association group a while back for continuing legal education credit for attorneys, and it was well received, and it's an area regarding employment law that often is not discussed or studied as much as I believe it should be, because the consequences, especially for an employee who works for a company, to be exposed to individual liability for claims raised by an employee, another employee of course, is substantial, and it's something that needs to be thoughtfully considered and evaluated in lots of circumstances. So let's get started. The individual employee acting within the scope of one's employment is traditionally shielded from exposure to individual liability. Now, individual liability means, of course, legal fault and responsibility. That premise of shielding individual liability represents the so-called general rule. There's lots of exceptions to that general rule, which this discussion is going to entail. This discussion will entail state and federal statutory claims and related case law, as well as some select common law exceptions to that rule. So if you haven't found out already through our discussions and your study, there's general rules and there are exceptions. And this is another area within the employment law context that exemplifies that point. Both employers and employees need to be at least aware that these issues are out there, particularly employees who have high-level management positions and individuals who operate companies, owners and high-level managers. So let's start. But before we do, I wanted to just share, and this is kind of unrelated to our employment law, but just a segue or side note. Winston Churchill has lots of different sayings, very well repeated statements over lots and lots of years, but this is one of my favorites, just to share a little bit about my personality. If you've been able to detect anything in our discussions, an optimist sees an opportunity in every calamity. A pessimist sees calamity in every opportunity. So there you go. That's our lesson for today. One of my other fans, of course, or I'm also a fan of Abraham Lincoln, and I'll share some information about that later as well. Not in this segment, but toward the end of the course. It's to tie something else together. Let's look at individual liability afforded under state statutory laws. And by the way, this is not covered in your course, but I do want you to have an awareness. And there may be some questions on your final exam relating to this area. But again, I understand you don't have it in your textbook. You will be receiving a very detailed handout or supplemental course material on this very topic. But here's what we're going to cover. The Whistleblower Act, we've already studied. The Illinois Wage Payment and Collection Act, which we haven't yet covered. The Illinois Minimum Wage Act. The Equal Pay Act of 2003, we covered that. Here's an act that we've not yet covered. Employee Classification Act, Employee Credit Privacy Act, and the Victims Economic Security and Safety Act. There's the Workers' Compensation Act, where individual liability is afforded as well. The Whistleblower Reward and Protection Act, the Illinois Human Rights Act, the Illinois Freedom to Work Act, the Employee Sick Leave Act. There's all kinds of employment statutes that contain reference to individual liability. Under federal law, and you may recognize many of these already, the Uniformed Services Employment and Reemployment Rights Act affords individual liability. Section 1981, the Family and Medical Leave Act, the Fair Labor Standards Act, which we'll cover, the Section 1983. We'll have some limited discussion about that later, and Title VII of the Civil Rights Act of 1964. Under common law claims, tortious interference with prospective business advantage, and tortious interference with the employment contract or employment relationship. Let's look at the Illinois Whistleblower Act, and there's some handout materials that you've already received on this with regard to the retaliation sections. But the employer, according to the definition by the legislature, means an individual. I've darkened the term individual. Sole proprietorship, partnership, firm, corporation, association, and any other entity that has one or more employees in the state. So that means if we're looking at jurisdictional coverage for the size, only one individual will confer the jurisdiction for the Whistleblower Act. And note at the end of this section of the slide, I've darkened some other words and terms, and that would be persons acting within the scope of his or her authority. In other words, they're carrying on activities on behalf of the employer. Vicarious liability is a term we've discussed. Respondeat superior is a term that has been discussed. A person acting within the scope of his or her authority usually will mean that the employer is going to be responsible for their actions. But in this instance, an individual may also have exposure to liability if there's been harm. The employee means, under the Act, an individual who is employed on a full-time, part-time, or contractual basis by an employer. Well, that means that even an independent contractor can be exposed to liability individually through the Illinois Whistleblowers Act. The Whistleblower Act claims something that is more of a lawyerly note is that there's no uniform judicial analysis. In other words, there's not a well-developed history of case law through our common law system to really develop, that's been developed to give us some predictive understanding of where the courts are going to end up on these points. It's still developing, and really that's the nature of our common law and the theory of our adversarial system when common law is applied. I'm just highlighting some of these laws, and again, this is to give you background information, and there's also going to be a handout that I want you to look at as well that will give a lot more information accordingly. But the Victims Economic Security and Safety Act. In that act, the employer is any person. So anyone who acts on behalf of the employer and discriminates or retaliates against an individual that is covered and has reason to invoke this law may be held to individual liability or accountability. So there's an anti-discrimination and an anti-retaliation component. The Illinois Wage and Payment and Collection Act. Let's look at this in a little bit of detail. Officers of agents deemed to be employers. Officers, I believe it should be, or agents deemed to be employers. There might be a typo there. In addition to an individual who is deemed to be an employer, any officers of a corporation or agents of an employer who knowingly, I've darkened that word, permit such employer to violate the provisions of the Act shall be deemed to be the employers of the employees of the corporation. What this means is that an individual officer or an individual upper level manager who is not authorizing overtime compensation or withholding pay compensation to an employee that has a right to receive same, if that's done knowingly, in other words, done intentionally, purposely, then that conduct could invoke personal liability against them. So there's always a risk, but one would think that typically if you're carrying out an activity on behalf of the employer, that risk will be shifted to the employer. Not so under some of these laws, and that's really the purpose or objective of this discussion. The Illinois Wage Pay and Collection Act is also an area where individual liability may result based on supervisory employee actions. And I'd like you to turn to your handout on these sections to give you just a little closer understanding of these points. There's some recent amendments to the Illinois Wage Pay and Collection Act. Of course, there is anti-discrimination and anti-retaliation features to that act as well. So in other words, if someone complains about not being paid properly, or they're complaining about a benefit not being authorized, and there is some adverse action that is taking place as a reprisal for the complaint, there could be exposure to individual liability through the anti-discrimination and anti-retaliation components of that law. And again, I want to just focus in a little bit of detail here on what that law provides. It's the Illinois Minimum Wage Act. The employer includes any individual, partnership, association, corporation, limited liability company, business trust, or governmental or quasi-governmental body, or any person or group of persons acting directly or indirectly in the interest of an employer. So, what does all that mean? It means that upper level managers, if they're acting either directly or indirectly to support the employer in relation to that employee and some violation of the act occurs, the Minimum Wage Act, then that respective individual employee could be held separately and individually accountable for the losses. And I've just mentioned that there's an anti-discrimination, anti-retaliation component to the Minimum Wage Act, and those violations also reflect the federal law, the Federal Labor Standards Act. There's some case law that's described in your supplemental handout materials, and if you'll take a look at some of those cases, I've highlighted them here. The case of Schneider versus Cornerstone Prince focuses on a supervisory authority and control test. That's very detailed. I'm not going to test you, of course, on that aspect, but I just wanted you to be aware that there's law, and there's fairly recent law in our jurisdiction on this particular area. So take a look at it and read it through. I'm not going to hold you accountable for the technical points or details. The Equal Pay Act of 2003. That's a state act. We've, of course, studied the Equal Pay Act, which was passed in 1963, which is federal. This is the state Equal Pay Act. And I wanted to have you be aware that under the definition of who's an employer, it could also include an agent of the employer who knowingly discharges or in any other manner knowingly discriminates against any employee because that employee has made a complaint to his or her employer or to the director or his or her authorized representative that he or she or any employee of the employer has not been paid in accordance with the provisions of the Act. So, if an employee believes that they have suffered pay disparity where they've not been paid equal wages or compensation to their counterparts of another gender, and they make a complaint to the employer, and if the employer, of course, is represented by an upper level manager or an officer of the corporation, should that individual make a decision that knowingly violates this act, they could be held individually accountable. So, a lot of responsibility to have some levels of authority and to make decisions on behalf of the employer. That decision making could invite and invoke personal liability. The courts ultimately will examine the definition of employer in the context of the Federal Equal Pay Act and the FLSA, the Fair Labor Standards Act. So, state courts looking at state Equal Pay Act definitions will look to the federal law to better understand how the employer definition applies and how it relates to various case circumstances. The Employee Classification Act, we've not studied that. It's an act that you might want to look at separately and on your own. Again, another example of individual liability because officers and agents are included. And of course, there are anti-discrimination and anti-retaliation features within the law. I think if you haven't got the big picture by now, the courts and the legislatures are very protective. I should say the legislature is very protective and the courts are willing to recognize how the legislature has attempted by the enactments to deter any form of retaliation. And in this area, as what we're focusing on during this discussion, that deterrence should spill over to even individuals because individuals may suffer the consequences on their own as well if there's known violations. Here's a law for you, the Employee Credit Privacy Act. I'm not going to test you on that, but it's something that I wanted you to have an awareness of. And again, the same holds true. There's individual aspects, there's anti-discrimination and anti-retaliation components built right into those laws, that law in particular, that relates to certain conduct. The Workers' Compensation Act. That's an act, of course, that we've studied already. Can there be individual liability? Well, most courts probably have not been strenuous in recognizing that, but I wanted you to look at the law from the statutes that applies. It shall be unlawful for any employer, individually or through any insurance company or service or adjustment company, to discharge or threaten to discharge or to refuse to rehire or recall to active service in a suitable capacity an employee because of the exercise of his or her rights or remedies granted to him or her by this act. Now, what does that mean? If an individual gets hurt on the job and makes a claim for unemployment compensation benefits, then there's going to be obligations on the part of the employer. Those obligations will prohibit any form of discrimination or retaliation for invoking rights under the Act. One aspect that's very clear so far is that only the employer is going to be the retaliatory discharge defendant. Only the employer. So the company itself would be the defendant in a lawsuit. Individuals have not been the source of liability for those claims. It all goes back to the company. However, individual liability for a civil action for violation and criminal sanctions for failure to provide and pay for coverage under the Act is certainly possible. So in other words, just to give you a little broader perspective, it's the law for employers to have workers' compensation coverage for their employees. If the owner of the company purposely, intentionally fails to pay for liability insurance, there could be civil actions that are possible along with criminal sanctions, and that could be on an individual basis as well as against the corporation. The Whistleblower Reward and Protections Act, that's something a bit different from the Illinois Whistleblower Act itself. This is where if there's fraud against the government or some government taxpayer-supported entity, and one can blow the whistle about that fraud, then there's going to be potential individual liability against an individual that fires or takes adverse reprisals against the person who blows the whistle, so to speak, or tries to bring to attention the fraud that might have occurred. Just another example of what I wanted you to have an awareness of. The Illinois Human Rights Act, we've already studied the Illinois Human Rights Act in the context of our discrimination laws, but I wanted you to make sure that you have an awareness that the Illinois Human Rights Act prohibits employee and the agent of employee to engage in sexual harassment. An individual can be named as an individual respondent for sexual harassment claims. So in a case involving sexual harassment where Illinois law has been invoked, not only could the company have potential liability for the sexual harassment, but so too would the individual alleged harasser be exposed to separate liability. Here's some new laws, and some of you have already covered these new laws at the very beginning of the course when I asked you in one of your early exercises to identify new laws that are effective January 1 of 2017. In these particular laws that of course relate to employment, the Illinois Freedom to Work Act, there's a provision that an employee is any individual acting directly or indirectly in the interest of the employer. So there could be individual liability under that act, but so far the Employee Sick Leave Act, there's no, at least the time that I put this together, there's no definition yet. I don't think there's any definition yet available, but there are anti-retaliation prohibitions. Let's look briefly at individual liability afforded under federal law claims. The USERA case, very interesting case of Bellow versus the Village of Skokie. That case is noted in your course handout materials. The judge recognized that individual liability could attach to a management level employee that's somehow involved in directly violating the ERISA Act to a covered employee. Interesting case, and it's there for your reading. Section 1981, we've already covered Section 1981 earlier in the course as a similar type of claim to Title VII, but certainly much more focused, and it was also the subject of an exam question as well. Again, certain cases involving Section 1981 are covered in your handout materials. The case of CBOCS West Inc. versus Humphreys, there the court recognized that individuals could be held accountable and liable for actions that violate Section 1981. Smith versus Bray, also a very recent Seventh Circuit case, recognized individual liability by applying the so-called cat's paw theory. Maybe I'll have an extra credit question later on about what is the so-called cat's paw theory with regard to employment law. I'll put that in my notes and we'll see if that's something that might come up later in the course. Family Medical Leave Act. In the Seventh Circuit or the United States Supreme Court, there's no recognition of individual liability yet. However, there have been multiple district court recognitions of individual liability in our jurisdiction. Now that, again, it requires you to have an understanding of the level of the courts, which I know you do because we've talked about it and you've studied it. The lower court would be the trial court. In state courts, that court is known as the circuit court. The district comparative would be the trial court, the district court on the federal level. The Seventh Circuit Court of Appeals is, of course, the appellate court from which the district court decisions are appealed. And in our jurisdiction, there's not yet, to my understanding, a Seventh Circuit or a U.S. Supreme Court decision that recognizes individual liability under the Family and Medical Leave Act. However, there are district courts, the trial courts in our jurisdiction for the federal claims that have indeed recognized individual liability. So something that will probably come up on the horizon and will be a trend to follow or track with regard to this area of law. The Fair Labor Standards Act, individual liability is of course applicable. There is a case from the Second Circuit in 2013, interesting case. It's noted in your, well, I should first of all say this, the Second Circuit 2013 case was where the United States Supreme Court denied cert. The U.S. Supreme Court ruled in March of 2013, declining to review a federal appellate court ruling that an industrial owner, as president and chief executive officer of a supermarket chain, is personally liable as an employer under the FLSA for his company's default on payment obligations pursuant to a settlement agreement with a class of store managers. So interesting case where the Supreme Court said, we're not going to take a look at what happened in this decision from the Second Circuit in 2013, where that president was personally liable. Section 1983 creates really no substantive rights. It's a mechanism by which federal rights can be enforced. Title VII, we've studied Title VII in a lot of detail already. And let's look a little closer at Title VII with respect to individual liability. The general rule, here we go again with the general rule, is that there is no individual liability. But there have been limited exceptions to that general rule, invoking the so-called alter ego theory. And that theory has been recognized by the Seventh Circuit most recently. I think there's a couple of cases since 2006, but one of the leading cases is Smith versus Castaway's Family Diner. There, an individual can be held an employer if that individual has authority and the interests are so aligned with the business as to render legal personification of the business literally that you can't distinguish between the two. The individual or the company, they're viewed as almost one and the same. And there's a case from 2015 that's in your material, your course material handouts, called Santiago versus Dr. Viren Patel. Very interesting case. Please look at that in more detail as well. Under state law, common law, there have been instances where individuals, even though they're working for a company and carrying out the functions of their duties, their jobs on behalf of the employer, have been held individually accountable. The Popco versus Continental Casualty Company case, I believe I already introduced that case to you earlier with a handout with respect to defamation and tortious interference. There's also a case that's more recent from 2016 called the Kaler versus Packer Group Inc. case. Again, these are for your reference, and if you'd like to look at them, they're certainly available online, or you can simply just Google those names and put in the sites, and you'll get copies of the actual case report. And this is for the attorneys that I made the presentation to regarding practice considerations, legal, ethical, and strategic considerations. Well, they really don't apply to any of you as you're not attorneys, at least not that I know that you are, but you might want to think about it from the perspective of a human resource aspect. Are there legal, ethical, and strategic considerations? Absolutely. Anytime that an individual manager, upper level manager, officer of the corporation is making decisions that may impact these particular rights announced in these state or federal acts and common laws that impact individual employees, there should be ethical and legal considerations in how best to approach issues that may come up along the way. Well, that concludes our presentation for this section. I hope that it's been informative and perhaps eye-opening to some of you, just given the level of responsibility that is often involved in these types of situations and the potential legal liability that may result. Thank you.